Yeah, so hi everyone. I'm Yasira Mahdi, and I work as a junior climate policy and food systems researcher at the Institute for Economic Justice. So welcome to this webinar on JET IP and embedding human rights and climate justice into climate investment plans. So this webinar is hosted by the Climate Ambition to Accountability Project. And the aim here is to facilitate a discussion on human rights and how it will intersect with the Just Energy Transition Investment Plan. Through our speakers, we will aim to discover if human rights have been adequately embedded into the JET IP and what the threats are as we invest more money into climate action. So again, welcome. Thank you for joining. I think please feel free to leave your name and your organization and also the country that you're from. Okay, people are already doing it in the comments, just so we can get a feel for who's in the room. Yeah, so to give you an idea of the structure of this session, of this webinar, so it will start with me giving sort of a short introductory presentation on human rights and what human rights are. And thereafter, we will have our three panelists each give 10-minute presentations on various aspects of JET IP, including things of like how it fits into investment law, what are the policy and government risks, and what social and procedural justice elements does the document speak to. So the panelists will present one after another, and thereafter we will have an open Q&A session. So please keep your questions written down or write them in the Q&A box so that we can get to them right at the end. And then also feel free to use the comments section and cultivate a discussion. And yeah, also just a reminder that this webinar is being recorded. Okay, perfect. So I think without further ado, I'll go into my introductory presentation before we go to the other speakers. I just need to find it. Full virtual mode. Cool. Can everyone see that?
Yes, we can.
Cool. So what is a rights-based approach to climate finance? So the disaster of climate change has many impending impacts, as we all know, such as stronger storms, intense heat waves, prolonged droughts, rising sea levels, amongst numerous other impacts. And the changing climate does not just impact the environment, but also human well-being, threatening numerous rights and also our very existence. This illustration here shows that at a global level, the right to life, food, adequate housing, and water and sanitation will be severely undermined as warming increases to 2 degrees Celsius. The World Health Organization predicts that climate change will cause 250,000 deaths per year between 2030 and 2050 due to malaria, malnutrition, diarrhea, and heat stress. And these are just some of the rights that may be undermined due to the changing climate. But the impacts can go much deeper, disturbing our societal systems and further undermining other rights. For example, our rights to education, development, and work through economic and infrastructure destruction, our rights to cultural heritage also through destruction, but also our rights to peace as climate wars break out, and finally, also the rights of the future generations. So it's all a bit doom and gloom, but I think we've realized the importance of focusing our attention on climate. And in the face of these devastating impacts of climate change, the international community has become more serious about addressing climate change. And there has been increased attention put on the financial resources needed to help developing countries to mitigate and adapt to climate change. This means that we have seen record numbers of climate financing over the previous decade, with global climate financial flows having almost doubled. This financing is needed for achieving our climate action goals. Yet, just as climate change will impact a wide range of rights, the governance and distribution of climate financing also has implications for the full range of human rights, including similarly the rights to life, health, food, water, housing, culture, amongst others. So the just transition describes this justice-based approach for a systemic move away from a high-carbon, fossil fuel-based economy into a low-carbon, renewable-based economy. But just because this term has just in it does not necessarily mean that justice is inherently embedded in the transition. There has been a range of human rights abuses associated with the renewable energy sector, including land grabbing, forced displacement, child labor, inadequate working conditions, limitations on collective bargaining and workplace organizations, exacerbated inequalities, amongst others. So we see examples of the Yubei region in China, where forced labor is being used to produce solar-grade polysilicon for solar panels, and this region supplies 45% of the globe's solar-grade polysilicons. But if you bring it down to a more local level, when we look at the shutdown of the Kermatic power station, this shutdown without following sufficient planning and sufficient adhering to procedural rights can have deep implications for people's livelihoods and also threaten surrounding communities and a range of their rights. And all of this is to say that this is not necessarily an inherent flaw of the just transition, but more with the failure of nations to develop appropriate labor and environmental safeguards that uphold human rights. And on top of that, the profit-driven manner in which financing occurs, which decides what is financed, how it is financed, and who is prioritized during the financing. So when we go into the human rights implications of financing itself, we look at what is the sources and the instruments. So when we're looking at financing, the sources and instruments of financing can be just as important as what project is actually being financed. So the sources of financing could be public or private, stemming from government, commercial to development financing institutions. And the instruments itself can range from debt to equity to grants, and all of these have rights implications or implications from it. So when we look at, we can use an example of one of the instruments. So for example, in South Africa, 59% or 36.5 billion of tracked climate finance is raised through debt. And of this total, 28.9 billion was provided at market rates, meaning that 46% of debt comes from market rate loans. And many countries have engaged, and this is not necessarily a problem right now, but many countries have engaged in debt at unsustainable levels, leading to an engagement in a wide array of strategies to appeal for debt relief or debt restructuring to make ends meet. And this debt has implications on rights. For example, in Zambia, they have seen soaring levels of debt as the country tries to fund infrastructure rights, but using high borrowing costs. And in 2021, it was said that Zambia had to cut health and social care spending by a fifth in the past 2 years to balance its budget. So this illustrates that this financing instruments does not occur in isolation, but has impending impacts on the social goods of a country. And as South Africa engages in more and more debt, it is important that the full extent of debt implications and right violations is understood. And this is why it's important to have a rights-based approach to climate financing and to have rights guide the financing process. But to go into more detail of what is a human rights-based approach. So according to the Office of the United Nations Higher Commission for Human Rights, human rights is a conceptual framework that is normatively based on international human rights standards and operationally directed to promoting and protecting human rights. And the primary aim is to analyze obligations, inequalities, and vulnerabilities, and to redress discriminatory practices and unjust distributions of power that impede progress and undercut human rights. So embedding a human rights-based approach into all investment plans and all climate actions ensure that we adequately assess the implication of the action. Human rights norms offer a binding framework for states and serves as a benchmark to determine if decisions relating to public resources are being made fairly or not. In other words, human rights help to define the basic demands relating to fiscal justice. So having a fiscal and a development policy with human rights approach embedded in it means that states are adopting measures that are different from the policies traditionally presented as necessary. For example, reducing public spend on basic services like health and education. But of course, preparing this terrain for the alternatives involves combating a range of phenomena which have prevented decisions which have presented financing decisions from prioritizing rights as it has done in the past. And these things can include state capture by elite, corruption, the dominance of fiscal injustice, promoting beliefs and doctrines of this injustice, and the absence of social movements' involvement in fiscal decision making. So all of this is building up to the foregrounding on really to discuss the investment plan. These are how human rights can impact, and how climate change impacts human rights, how human rights impacts financing decisions, and how interrelated these things are. And this is all a foregrounding just so our speakers can then speak about the JET IP. So just for those of us who don't know what the JET IP and the JET P is, at COP27, South Africa signed an 8.5 billion bilateral deal with international partner groups called the Just Energy Transition Partnership, and or the JET-P. And the condition of this JET-P was that the South African government lay out a 5-year investment plan for its plans to finance the energy transition. And this gave rise to the Just Energy Transition Investment Plan, which lays out South Africa's energy transition financing needs from 2023 to 2027, requiring a total of 1.5 trillion. So while the JET-P provides a unique opportunity for climate investment to drive South Africa's energy transition, it's also a complex and technical process that can leave affected communities and workers behind if not implemented properly. So climate financing is also vulnerable to predatory tactics of foreign development aid and a global financial system, which, like we've said, prioritizes generating profits for financiers at the expense of effective adaptation and mitigation efforts, and also associated justice outcomes. And then on top of that, the lack of understanding and capacity around climate investment in South Africa can have serious implications for human rights and gender equity. So there's a need to embed a progressive rights-based approach into climate financing and associated investments so that these investments can meet the development challenges of the country as well as associated climate targets. So yeah, that's just a bit of backgrounding and a bit of foregrounding of what a human rights approach is, what does it mean, and what are the implications for financing. And then without further ado, I think we can get into the presenters and their presentations that really delve deeper into the investment plans and discuss the technicalities of the plan and also the justice implications of what is said in there. Yeah, so I would like to introduce our first speaker, who is Celine Tan. She is a professor of international economic law at the School of Law, University of Warwick, and co-director of the Center of Law, Regulation and Governance of the Global Economy. And her research centers on exploring the aspects of international economic law and regulation with a focus on international development financing law, policy, and governance. And Celine has published on issues relating to law and governance of the international financial architecture, sovereign debt, climate change, sustainable development, the role of international finance institutions, and human rights. So yeah, that's a lot. And she'll be contextualizing the JET-IP within the multilateral climate finance architecture and also talking about the finance, regulatory, and policy risks. So thank you, Celine.
Thanks, Yazira. Can you hear me?
Yes, yes.
Brilliant, thanks. So I'm just going to share my screen. Just give me a second. This is always very, very cool because I don't actually know what's happening. All right, brilliant. So yeah, so Yazira's talked a little bit about the JET IP, and I wanted to really talk a little bit about how the JET IP fits into the sort of global climate finance architecture, and then, rowing, forward from that to look at what are the implications of the structural and systemic global issues and the impacts on South Africa, particularly on South Africa's capacity to respect, protect and fulfill human rights, and also to achieve climate justice. So just wanted to take you through these issues. And just by way of apologies, I'm actually sitting in a kind of public space, so you might get some background noise coming in. So thank you all for being patient with me. So just a little bit on the JET IP, sorry. When we look at the JET IP, we've got to look at it in the context of the multilateral climate change, the multilateral climate regimes, and how climate finance fits into existing international obligations, because there's an international architecture around this, which I think is really important for campaigners and policymakers to take note there. So what's the purpose of climate finance? When we talk about climate finance, we look at it as central to ensuring the legal obligations of the global climate change regime are met in terms of mitigation of climate change, adaptation to the consequences of climatic changes, and then loss and damage financing as well, which is basically, in effect, reparations for damage, losses and damages that are not we cannot remediate from climate change. So we have a multilateral climate regime under the United Nations Framework Convention on Climate Change, which has the convention itself, but it's also got associated agreements. The Paris Agreement, notably, is part of the UNCCC process. And this is a multilateral regime and obligations of parties to undertake mitigation measures and to adapt to climate change and compensate for climate pollution. That's the obligations of parties. Now, all countries have obligations. All the state parties that have signed up to the UNCCC have obligations, but developed countries have greater obligations to mitigate climate change, and to provide finance and technology transfer to developing countries to support them in their mitigation process. This is in recognition of basically the historical responsibility of developed countries to creating the conditions for climatic changes today. So what we need to remember is the establishment of the Just Economic Transition Partnership, which is a kind of multi-country partnership, is a financing platform that has been established by developed countries, and its implementation in South Africa through the JET IP, the JET Investment Plan, must be situated in this context. So when we talk about what is the JET IP is a form of country platform that's used to generate resources to deliver a set of country priorities. In this case, the decommissioning, the decarbonization of energy sectors, particularly the transition away from coal, right, as a source of energy production. And it's also a platform actually to coordinate the sort of policy, regulatory, institutional support to achieve these priorities. And these priorities are determined through South Africa's nationally defined contributions, the NDCs, which is a set of policies and objectives that the South African government is committed to under the UNCCC process. Okay, so the JET IP is actually more than a financing mechanism. It's just not a collection of financing instruments. It's actually a blueprint for social and economic transformation, and therefore we need to look at it in much more deeper light. So just looking at the principles of climate finance and how then we need to look at the JET IP in the context of these principles. So the JET IP, as I said, you need to embed it within the multilateral climate regime, the UNCCC process, and the obligations of parties to undertake mitigation measures and to adapt to climate change, right, have to be framed within this process. And it's based on the principles of equity and common but differentiated responsibilities and respective capabilities, the CBDRRC. And this is really a fundamental principle of the climate regime, right? As I mentioned earlier, this is in recognition of the fact that developed countries have had it has the historical responsibility for climatic changes, and that the obligations on developing countries, including South Africa, to mitigate climate change must be dependent on the financial resources and technology transfers that are available by made available by developed countries. So there is, you know, this is really fundamental to any sort of platform partnership that developed countries have with developing countries in facilitating climate financing. Okay, so developed countries, just to give you an idea, you can look at the UNCCC process. They have to meet the full agreed full incremental cost of mitigation and adaptation, and that financial resources have to be new and additional. And this is really important, right? I mean, new and additional financing is absolutely key, because you cannot have finance that is taken out from aid, from other official development finance that are going to other needs of developing countries, such as healthcare and education sectors. But we are seeing increasingly that this is the case, and this is what advocates and policymakers need to be very, very aware of, okay? The Paris Agreement itself emphasizes the significant role of public funds, so that public financing has to be the default, and there has to be support for country-owned strategies and their transparency and predictability of financial support. Now, what does that mean for the JET IP? It means that in addition to embedding the principles of equity and CBDR within this kind of partnership between South Africa and the developed countries that are and the multilateral development agencies that are providing the financing, it has to be undertaken in accordance to these principles, right? The JET IP itself also provides that it should be guided by debt, sustainability, cost effectiveness, harmonization of climate action with socio-economic considerations of transition, and the establishment, importantly, of governance and safeguards to manage these risks, okay? Now, we looked at the JET IP, and we thought that there are three concerns of ours, three particular issues that have raised significant concern with us that could undermine these climate sustainable objectives and the principles of climate finance that are multilaterally agreed, right? And they could give rise to legal regulatory risk beyond the JET IP. They are, Yazira mentioned some of them in her presentation earlier, their reliance on debt instruments as modalities of financing the JET IP, the reliance of the private sector financing, use of official sector finance to de-risk, so to reduce the risk of financial investments through blended finance and PPPs or public-private partnerships. Now, I'm not saying that actually there's no role for public finance in terms of encouragement or encouraging private finance, but we need to think about this in a more targeted and holistic way, rather than the way that it's being done through the JET IP and other processes, similar processes. There are limited financing social safeguards to operationalize the just transition. What's just transition mean? It means that when you transition to a low carbon economy, you don't leave people behind. There are no socio-economic transition risks because they're massive, particularly for developing countries. So we need to ensure that there is this just transition. We don't think that the plan as it stands necessarily operationalizes this. Okay, so some of the financial regulatory policy risk of the JET IP, and you can read more about that in our evaluation report, which I think IEJ will send out to participants as well. Signposts, these are things that we've already discussed within our report, so I'll just go through them and you can have a look at them, the report in greater details. Their reliance on debt instruments, so there's a lot of reliance, as just Yura says, on loans and securities to finance transition programs, commercial loans guarantees, and also issuance of this thematic sovereign and corporate bonds. This is very, very of the moment now, green and sustainability linked bonds to finance climate transition. This increases the debt risks in a number of ways. So it increases state contingent liabilities, which means that although it's a private sector debt, if the private sector takes on this debt and it can't pay it off, the state may have to take these liabilities on. So it increases actually the debt burden of the state. There are higher exit costs for state parties, which are locked in through contracts. And my colleague Anil will talk a little bit about that in terms of the way that it locks in states through investment agreements and investment contracts. And it importantly heightens state exposure to volatility in international financial markets. Obviously, a lot of the debt instruments that are being proposed will expose South Africa to foreign investors and international capital markets. So you do actually expose South Africa to greater volatility in international financial markets, and it creates kind of like increased transmission nodes for instability globally if we're not careful. There is also a situation with the legal and regulatory reforms that are linked to financial instruments. There's a lot of loans and grants from suggestions for loans and grants from multilateral development agencies and bilateral donors and creditors. But again, we've got to be careful about the reforms that are linked to this that might constrain the ability of the South African government to undertake certain measures to actually transition properly to ensure a just transition. So it's paradoxical here. The diversification of creditor base, the increase in foreign creditors, it has to be taken into account because we've had the context of the existing gaps in the sovereign debt architecture. You might have been aware that a lot of developing countries are having significant problems restructuring their debt, particularly highly indebted developing countries. And these are importantly debt owed to private creditors through the issuance of sovereign bonds. And this is a very unpredictable source of financing, but it's also a very difficult set of creditors to deal with because they're so diversified. And so restructuring, because there isn't a statutory restructuring process for external creditors, we get into a situation where if there is more debt that is issued outside South Africa, commercial lenders outside Africa, you're tied into the legal jurisdictions outside South Africa. There's very little the South African government can do in terms of influencing the debt restructuring if the foreign creditors do not want to come to the table in a debt crisis situation. We see that now in many, many countries, including Sri Lanka and Zambia. And there's a lot of conversations happening there, and Ghana as well. So there's a lot of backlogs in terms of debt restructuring. We've got to be careful about that. So this is really important. I know we're running short of time. Yazira is going to send me a thing in a minute. So one of the things that we do need to remember is that this, again, the JET IP isn't just a set of financing instruments, it's a blueprint for social and economic transformation. So there is a potential possibility of the JET IP and the reforms in the JET IP of constraining actually the policy and regulatory autonomy of developing countries such as South Africa, which, as I said before, can undermine climate justice and human rights. There is a danger that the JET IP and the broader JET platform remains a donor-dominated process. So that outside the official financial mechanisms established by the UNCCC. Now, within the UNCCC, there is a modality for financial for supervising the technology transfer and the financial resources. Remember, I mentioned earlier that this is a core to climate finance is core to countries meeting their obligation under the multilateral climate regime. And so there is this process by which it should be supervised by state parties. But unfortunately, the JET IP exists outside this framework, and it will be premised on an aid framework, which is very, very regressive and not actually necessarily compatible with the principles of CBDRRC and other climate finance principles. Okay, and then of course you have this financing agenda that's premised towards mobilizing private finance, market mechanism. They risk prioritizing the interests of private commercial investors and creditors over public interests. Why do I say this? Because if you're trying to generate private investment and there is limited public investment in the transition process, then you will necessarily gear and structure those investments and the plans and what you want, what reforms you need to what can be funded or what is attractive to private investors and private creditors, which may not necessarily be what is important or necessary for communities and for the country itself. So we have to remember that this is a policy constraint. If you're looking to private investors, then there is a danger that you look and fund certain sectors over others because they're not very attractive in terms of profitability for private sectors. And there are accountability and governance gaps due to the fragmented approach to financing and managing social economic transition risks. Yeah. So just as a conclusion, I think because I know I've gone over time, I just wanted to stress here that the global financial system will be central to the mobilization and the delivery of climate finance. But realigning this to climate finance target will be challenging because there are inherent structural deficits within the financial policy, international financial architecture, which I've mentioned, some of which I mentioned before. And developing countries have less voice and representation in the international financial architecture and through the aid framework, which is what the JET IP is embedded in. It's not embedded within the UNCCC process, which is supervised by the state parties to the multilateral climate convention. It's actually embedded within the aid development finance context, which is which is less representative. Okay, it'll be driven by regulatory frameworks set by developed countries, which actually means that the climate action that will be financed will not necessarily be driven by community interests and domestic interests of South Africa. It will be geared towards donor interests, and that sets up, in a way, a parallel regime to the UNCCC process, where countries will be driven perhaps to undertake mitigation measures without the necessary finance, which undermine the obligations under the UNCCC. So it's really important that we look at it very holistically, that climate finance must be part of a broader package to reforms the current system, and South Africa needs to look at their commitments under international economic law as well as its commitments under climate regimes, and look at we need to examine the implications of these broader agreements in terms of what the JETP will impact on in different sectors, and they have unintended consequences, which my colleague Anil will talk about after this. And so just as end of the slide, this is, if you want more details of our work, you can go to this website. It's the Climate Finance for Equitable Transitions website, and it's a multi-institutional research and impact policy project that I'm very pleased that we're working now with IEJ to drive this forward. So we really look forward to your comments and engagement in the future. So do feel free to contact us through that website, and we look forward to discussing and engaging with you. Thank you.
Thanks so much, Celine. That was a very interesting presentation. And I think it touched on a lot of those you could allude to the human rights implications of a lot of these things like debt, and also it's interesting that you mentioned that the Paris Agreement encourages public financing as a default, but we see that that's not really the case in the JET IP, and also the implications of what it means to encourage the private sector to so heavily invest in this transition. So yeah, that's very, very interesting. And if you have any questions for Celine, please leave them in the Q&A box or write them down to be asked at the end of the session. But without further ado, we'll go into our next speaker, which is Anil Yilmaz, who is a senior lecturer in the School of Law at the University of Essex and the co-director of the Essex Business and Human Rights Project. And her research bridges a gap between corporate law, international investment law, human rights law, and tort law, examining how these areas can and should interact to operationalize human rights standards in the modern business context. So yeah, I'll hand over to Anil, who will be exploring investment law and social and economic transitions and governance risks of the JET IP. Thanks, Anil.
Thank you, Yasira, and thank you, Celine. And thanks for inviting us today to share some reflections on the JET IP. I am going to share my screen as well. Go, and then just, is that okay? I think that should be okay now, right? Right, I'm going to just follow on from Celine's presentation, following on the theme of the JET IP and certain risks that the arrangements that are being made and proposed can pose going forward in terms of policy evolution, but in terms of
sorry, Anil, I'm going to stop you there and say that if your slide is showing the presenter slides rather than the slides on our thing.
Okay, I don't know how to change that.
I mean, it's fine if you want to.
No, that's fine. I'm gonna just change it, but thanks. Share screen. Okay, is that better now?
Yes, perfect.
Okay, thanks. So yeah, I'm gonna just talk about the investment law risks, and I'll talk a bit about JET IP's coverage or lack of coverage, really, of human rights risks, and we talked about it in terms of social impacts and governance risks, but I think really there's a lack of attention in the JET IP to human rights risks specifically. In fact, if you do a word search in the JET IP, there's no reference at all to human rights. That is quite concerning. Okay, okay, now I don't know how to the next slide. Okay, here we go. So as Celine has explained, and as Yasira has explained before, what JET IP does is, one of the things that it does is to create basically enabling environments for private investments to come into South Africa for the energy transition. It's also allocating funds to decommissioning of coal power plants and coal energy installations. And so I'm going to talk about the risk associated with the transition away from existing investments in coal, oil, and gas. But I guess in the case of South Africa, coal is the primary concern because it does the country does heavily rely on coal, and it does have communities that heavily rely on coal for livelihoods, but are also affected severely by the impacts of coal production. But we're going to also look at investments, incoming investments that will be made under the JET IP in the renewable energy sectors, and how these can pose potential liabilities, regulatory risks for South Africa, but can have also human rights impacts. So what we see in the JET IP is a set of incentives and promises and arrangements to attract private investments in climate action, in just transition, which is a public good. And this would attract the needed investments. This is likely to attract the needed investments, the needed technology, but it can also increase the cost for host states like South Africa to adjust policies in the future. And what I will specifically focus on here are the investment law risks, because international investment law instruments like investment treaties or investment contracts that South Africa may sign with future investors, or even licenses that it grants to investors, can give rise to disputes in the future if action by South Africa, by host states, to adjust their policies in the future have detrimental impacts on the profitability of the investors' investment, basically. Right. So what international and domestic investment protection standards do, and I will also refer to domestic protection standards here, because South Africa is actually one of the few countries that have moved largely away from international investment treaties. It still has a few international investment treaties that are in force with certain countries, including countries like Sweden. But for the most part, it has actually moved away from relying on traditional models of investment treaties to attract foreign investments. What international investment treaties do is basically to provide guarantees to foreign investors to protect their economic interests against government interference, things like expropriation. So if a government expropriates directly or indirectly an investor's investment, there will be protections in law against this kind of conduct, and the investor will be compensated for that expropriation. But it also, investment treaties typically also extend beyond protections against expropriation and also cover things like unfair treatment, which have been very generously interpreted by international arbitration tribunals that have applied these standards. So concepts like indirect expropriation and the fair and equitable treatment standard that we find in investment treaties have been interpreted quite generously and can capture any kind of regulatory almost a reform that is introduced by host states in the pursuit of public interests that then make the investment more costly or less profitable for the investor. And I'll give a few examples later on. But these standards can also be embedded in domestic laws. South Africa has a Protection of Investments Act that applies to the protection of investments that does adopt similar standards to what we find in investment treaties. But the difference is obviously state has more flexibility to amend its domestic law to meet its needs, whereas it's much more challenging to walk back from international commitments, especially because they're backed by enforcement mechanisms like investment arbitration, international enforcement mechanisms that can be quite powerful in enforcing standards. And there's often sunset clauses in investment treaties. So even if a country withdraws from a treaty or denounces it or terminates it, it can continue to apply from 10 to 20 years after the withdrawal from that treaty. And considering the urgency of climate action and the urgency of energy transition, 10 to 20 years can be quite a significant timeline for tying the hands of the governments to take climate action policies, to implement policies that are geared towards just transition. So as I said before, policy reforms such as, if you're introducing more stringent environmental protection standards or more stringent healthcare standards, or if you're amending licensing terms or canceling a license of a business that is quite polluting, let's say, these may give rise to investor-state disputes. And one of the biggest concerns, in my view, that is raised by the investment treaty system and investor-state dispute settlement is that states have been asked to pay very high levels of compensation that are unlike what we see is awarded by any other type of international court, and any other type of domestic court, really. I mean, I don't have data on domestic courts, but typically, if we look at kind of jurisdictions within the EU, we'll see that these levels of compensation are not being awarded for investment disputes that go to domestic courts. Investment tribunals use a method often called discount cash flow, which basically bases the value of the investment on future profitability. So that if a license of a coal power plant is cancelled, for example, because South Africa is transitioning out of coal, then South Africa may have to pay compensation to these investors at levels that would be significantly higher than the market value of that investment. And that is quite concerning, because what it does is to make the cost of climate action much higher than what it would be if it wasn't for the investment protections. And these standards run in parallel to the JET IP, even though they're not really obviously mentioned in the JET IP. Any kind of steps or arrangements or investments that are being made, that will be made under the JET IP, can be subject to investment treaty standards or domestic investment standards that are present in South Africa, or if South Africa does enter into investment contracts with investors, with these foreign investors that will come under this framework into South Africa to invest in renewable energy. Again, there may be provisions in those contracts that may protect the investor's interests. Obviously, the investor will want those kind of terms in their contracts, but may make it harder for the country to, in the future, amend the terms of the agreement or amend the regulatory framework within which the investment operates, even if these amendments are done in pursuit of public policy objectives. So it's quite important to bear in mind that mining and energy sectors have brought, they really share the highest percentage of claims within the investment arbitration framework. They're the most litigant, really, industries. And if we look at recent cases that were brought before investment arbitration tribunals under investment treaties, one very recent from last year, Rockhopper and Italy, Rockhopper versus Italy, and another one, which is Eco Oro versus Colombia. These cases, the first one involved an offshore oil project, offshore oil and gas project that was cancelled after the exploration phase because of its potential impacts on the marine environment. And there were significant local protests against the project because of environmental concerns and climate change concerns. Italy was then ordered to pay nearly 200,000 euros compensation, 200 million euros compensation to Rockhopper because of this project never actually going forward. And that's a really significant amount of compensation, even though it's not the highest ever award that we see in investment treaty disputes. It still is significant because this was a project that never even started, that never even went beyond the exploration phase. And yes, exploration is a costly effort in oil and gas. And similarly, in renewable energy projects, there's a lot of upfront costs that investors undertake. But even though there were costs involved in making the exploration investments in the Rockhopper case, the 200 million euros were not really warranted, in my opinion, in this particular case. And similarly in Eco Oro and Colombia, this was about a mining project in a páramo in Colombia, which is a wetland system that is really important for the environment, but also it's a it's a carbon capture, carbon storage kind of ecosystem. And there were lots of twists and turns in the evolution of this project, but eventually the project did not go ahead, and the licenses were cancelled on the grounds that it was environmentally harmful. And again, Colombia was found liable. We still don't know actually the amount of compensation that Colombia will be asked to pay. That part of the dispute wasn't decided the last time I checked. But so we can see that if governments take steps to cancel projects or block projects because of pursuing a just green transit, because on the grounds of pursuing a just green transition or pursuing climate action policies, there are investment law risks that can make that more costly. So the other concern that we highlight in the report is that these arbitration tribunals mostly operate without transparency. There's no room for genuine involvement of local communities and interests. There are opportunities to file amicus briefs, but this is a very limited option. And there is not really, you can't really bring the voices of local communities into the settlement of these disputes, even though these kind of disputes, intimately involve local interests, local community interests. So it can, the architecture of investment law, both in international level, but also domestic investment law, can limit the responsiveness of state to evolving science, especially when we look at climate action, but also to changing economic and social conditions. And as Yasira has mentioned in her presentation, we know that renewable energy investments themselves can have human rights and social impacts. They can have environmental impacts. Therefore, we can't simply say that these are beneficial, and while they have important contributions to the realization of human rights in tackling climate change, they also can come with social and environmental and economic impacts. So the main risks that we highlight in the report is basically fossil fuel asset stranding. As I said, South Africa's reliance on coal will require assets to be stranded, projects to be, power plants to be decommissioned, projects to be cancelled or phased out. These can give rise to disputes, both at the domestic level and at the international level, depending on who the investors are. But also protection of renewable energy investors has given rise to a wave of investment treaty claims in Europe, when certain European governments in south of Europe specifically have, after giving very generous subsidies to renewable energy investors, then they started withdrawing some of these subsidies as the business became profitable enough, and countries were going through financial difficulties. They withdrew some of those subsidies, and some of this happened overnight, and some of this happened through different more processes that were more diligently conducted. But so these gave rise to about 80 investment treaty disputes approximately, where investors were able to secure compensation for having their profit levels reduced. I'm not talking about projects being cancelled. I'm talking about profit levels being reduced from what they used to be when these projects were able to benefit from subsidies. And to be honest, the decisions were not all the same. Some arbitral tribunals have found that governments were liable to pay compensation, and some found that they weren't. Actually, there were no breaches of investment treaties. And that also tells us a lot about the unpredictability of the system, because it doesn't operate in the traditional model of kind of how domestic courts operate. It doesn't have a system of precedent. Arbitral tribunals are not bound by each other's decisions. They get influenced by other tribunals' decisions, but they can come to conflicting outcomes and decisions about similar disputes. So what we have proposed as an initial kind of as an initial evaluation was that South Africa's rejection of the investment treaty system to a large extent, not completely, is good in this context, and that it's better for South Africa to rely on its domestic act on investment protection. But what happens when host states actually do not have investment treaties is that investors will try to get investment contracts in that will be signed with individual investors, between individual investors and governments, which will contain arbitration clauses, typically for dispute settlement, which can again take the disputes outside of the. Sorry, Yasira.
Just wrapping up.
Yeah, just wrapping up. Outside of the system, of the domestic system, and we can see similar problems emerging with that as well. So it's quite important for South Africa to be vigilant when it's designing the legal framework under which these investments will arrive and will operate. I'm going to actually leave it there, not to go any further, but happy to answer any questions. Thank you.
Thank you so much, Anil. That was a great presentation. Also, I realized that you and Celine were talking about the report, but I didn't actually give any preface to say that there's been a report that IEJ, along with the Climate Finance for Equitable Transitions, or CLIFT, which Celine and Anil are part of, developed a submission. So when it was opened for commenting, the JET IP was open for commenting by the task team. We collaborated to develop a submission and critique some of these areas. So all of these things are in that document, and it's really explained quite meticulously. So we will have a presentation. I mean, we will send it out to everyone here. But yes, thanks, Anil. If anyone has any comments or questions, please write them down or put them in the Q&A box, and we'll get to them towards the end. But before then, we just have one final presentation from Alia Kaji. So Alia Kaji is a public financer campaign with 350africa.org, a climate justice organization supporting movements across the continent. And she has a background in climate change and development, and her work focuses on principles approach to climate financing, aiming to embed justice into how funds are mobilized towards climate action and the just transition. So Alia will be speaking on the JET IP and the efforts to realize social and economic justice. So yes, without further ado, Alia, I'll hand over to you.
Thanks, Yasira, for having me in this webinar today, and really, really informative presentations from the two speakers before me. I think Yasira and Lingiwe know I've just come back from maternity leave, and lots of things have changed since I left. Lots of research and thought leadership on the JET P and the JET IP, lots of new names and organizations in the participant list, and lots of updates to Zoom, which I'm still finding my way around. But I think I'm even listing those changes in that order of importance, because what I was hoping to speak about today is how do we actually take this incredible information that we've been presented with today, and how do we do it? How do we use this information and embed it into the processes that we're speaking about, and how do we do it as civil society and members of the public? And I think a lot of the work that we've been doing within 350 as the public finance campaigning work, but also as the Fair Finance Coalition of Southern Africa, is where do we even begin? So I realize now I forgot to put that in my bio, but 350 Africa and 6 other organizations in South and Southern Africa are part of something called the Fair Finance Coalition of Southern Africa, where we actually focus on public finance institutions and their role in climate change and the just transition in particular. So how do we actually translate a lot of this information into campaigns? And how do we translate this information into what we are demanding from these institutions and these organizations to see the changes we are calling for? And I was trying to prepare a presentation and topics and challenges to speak on, but I realized it would actually be a lot better to talk just off the bat, but in response to the presentations before me, because how quickly the sector evolves is sometimes off-putting because a lot of these terms, a lot of these processes can become very complex and very difficult to engage with on a practical level. And so as the Fair Finance Coalition, just some history, when the JET IP and the JET P was announced at COP26, what the coalition has focused a lot on is actually demanding and calling for transparency and spaces for consultation in these processes with the decision-making and advisory bodies in South Africa. So that would be with the Presidential Climate Commission. So engaging with the task teams over the JET-P, but also just broader climate change processes in the country, and working with a lot of other civil society members and also some community-based organizations as well in how do we engage in these spaces. And moving a little bit away from climate change campaigning to climate finance campaigning was actually a bigger pivot than even I anticipated as well. I think I've been working in the climate change sector for about 10 years now, but moving into climate finance, which is really instrumental, is a big shift, because when we started doing some campaigns in finance, it is difficult when dealing with, I think, those who are well-versed and trained in the field. So looking at how do we take these topics of finance and economics to those who don't normally speak about it? How do we break apart these topics? How do we actually engage in these conversations where we do eventually succeed in getting spaces for consultation? But what do we do once we get there, when often we are told these topics are too complex, it's difficult to engage in? Look, we're just going to give you information, we're just going to give you updates, but you know, as civil society or as the public, or especially as affected communities by the just transition and the processes associated with the just transition, this topic of financing is too complicated. And so what we really spent a lot of time doing last year was, I think, trying to open up the space. I think taking a lot of inspiration from IEJ and rethinking economics, and how do we actually broaden the topic of economics and finance, and actually making a lot of the language more accessible. But most importantly, I think affirming the rights and the position of civil society and the public to engage in these topics. I think actually building up the confidence of a lot of the actors that I work with and that I know to have a right and to have a say in this topic. And the way we tried to do that last year, I think looking at a public finance context, especially in South Africa, that is not just looking at our national budget, looking at our public finance institutions, you know, and our socioeconomic challenges such as inequality, poverty, and unemployment. We're really working off the back foot here. So taking positions where we acknowledge the socioeconomic challenges that we do have, and thinking, how do we bring everybody along with us as civil society, if that's what we're calling for in the just transition itself, that leaves nobody behind. So I'll just share some information about the event we had last year, which was a town hall. So planning an event where we say this information is for everyone, this information will affect everyone, this information should be engaged on by everyone. And let's bring different people from civil society, community-based actors, organized labor into this conversation, and how do we all relate to this information? And what we came out with was a set of principles for climate finance, predominantly from civil society and organized labor and community-based organizations. And I can show a video at the end, which is only about 3 minutes, that just go through these principles as well. And the importance of these principles really talk to the challenges that we do have. So how do we engage on topics that exist, such as energy poverty, such as energy inaccessibility? How do we look at climate finance as an opportunity to address these when we know we're working off the back foot? And so the the position of principles and a principled approach is bringing everyone together and affirming our position to lobby for more equitable and just finance in the way that it is raised, in the way that it is mobilized, and as you said earlier, Yasira, in the way then that it is implemented, because of the instruments and mechanisms that can actually shape the designs of how these projects work. And so what we then moved on to do from the town hall on climate finance in JETP last year is realizing that a lot of this information still needs to be broken down and explained in a way where people can engage with it. If you do go to a consultation, if you do go to a space where it's coming, let's say, to your area, to your sector, to your community, how do you engage in an informed manner? And so next month, being July, many of the people I think in this space are already attending or presenting. We were looking at having an event, a 3-day event called the Fair Finance School, where we're using a lot of case studies on community-based projects, on previous examples of climate financing and its inaccessibility of communities to climate finance, and how do we break down these principles and these existing initiatives and work backwards from there to identify where exactly are the opportunities to embed human rights in the climate financing process. And we're trying to bring together, I think this really hard job of very technical information, but then, as has been mentioned, point in the intersection where lives are affected in the coal belt, in communities, in areas where projects are going to be affecting your daily lives and daily livelihoods. And so we're bringing together, experts from a technical space. I see members of Rabia Transitions on the call as well, to those from community experiences in South Africa in particular, where people and representatives have engaged in consultations around Medupi, the power plant, for example, and how communities have been affected. So I think it's going to be a continuous process, but essentially the key messages, I think, would be how are we taking, I think, lived experiences as our tools and our mechanisms to embed into the financial process. And I think actually affirming our positions as civil society to be in that space. And we're starting by doing this. We're starting to do this by speaking about principles. So how can these principles underpin these decisions, and assessing processes according to these principles, whether we're looking at a deal itself or what I think various experts are starting to talk about in terms of not just deals and projects, but entire pathways towards a just transition. So looking at processes wider than 1 or 2 projects itself, but initiatives that are national in scale, particularly when we look at institutions like development finance institutions that operate at scale. How can we apply principles at scale? How can we apply principles that bring along everybody at the same level of understanding and equality in that way? So unfortunately, I don't have a set answer for how we embed, but this is the way the approach that we're taking to offer, I think, the broader public and colleagues in the space towards climate finance, where it has been an incredibly complex and technical topic, but something that affects daily lives. So how do we bridge this gap between experts and the public? So I'm not sure how much time I have left, Yasira, but I can try to share my screen just to show you the types of principles that we have been engaging on. It's 2 minutes and 20 seconds. I don't know if that would be of value.
Yes, that's fine. That's fine.
All right, let me just open it up. Here we go.
Is there supposed to be sound?
It's just backing music, so not important.
Okay, cool.
Yeah. Okay, I think that's it. Thank you so much, Yasira, and I'm happy to answer more and expand in the Q&A.
Thank you so much, Alia. I think that really helped and gave us an idea on how to actually break down these things and how to advocate in some ways on a ground level. Yeah, please feel free to lift up your hands, to ask questions. I see that there's already some questions in the question and answer box. So I don't know if we want to go to those. I mean, Anil, there's a question for you. I don't know if you want to answer this. So it says, thank you, Anil, for this overview of the investment treaty system and a happy reminder that South Africa's rejection of the system in the main really puts us in a good state. Even so, I'm curious about whether you have done, are aware of any assessments of South Africa's investment protection regime and how it is applied, and what this tells us about what we might expect around further fossil fuel investments and the potential of stranded assets into gas infrastructure as well as renewable energy investment and potentially likely to be an affordable and anti-competitive energy unit costs that are locked in under power purchase agreements.
Shall I just, I think the person who's asked that question left, but I can just answer very quickly. I have done a very cursory, or I've looked at very cursorily at what South Africa does in terms of investment protection when we were working on the report. But there are South African scholars that have worked on, that do work on investment law in South Africa, and there's some scholarly work on this, but I haven't come across any specific research on how actually the Domestic Act has operated ever since it came into force, I think in 2015, because it is much more limited than investment treaty protections. There is a more constrained definition of property rights of investors, and there is no references to some of the standards that we find in investment treaties. So I'm just speculating that it will be much more constrained in terms of protecting investments. That is not to say that investments don't deserve protection, but it is to say that they deserve protection that is, appropriate levels of protection, and that is not unfairly prioritizing, risks or losses that investors face over the risks and losses that communities face in the process of investments, but also specifically in the process of asset stranding, in the process of renewable energy investment introductions, etc. So it would be really worthwhile to, I think, research this further, to look at court precedents from South African courts on how investment standards have been interpreted. But one thing that we note and that's where I will kind of finish my answer. One thing that we noted in the report is that there are still investment treaties that South Africa is a party to, and these can still be utilized by investors, because investors can, shop for treaty protections. They can incorporate easily companies in those jurisdictions that have investment treaties with South Africa to then benefit from those treaty protections once they fear that there will be an investment dispute. I'll just leave it there.
Thanks so much, Anil. Okay, I'm going to move on. So Celine, thank you for answering questions in the Q&A box. Alia, I'm going to list off a few questions for you to answer. So the first one is, thank you so much for the well-articulated and informative presentation. I've learned a lot about the JET IP in a short space of time. My question is based on the possibility or readiness of South Africa actually transitioning from the use of coal to a cleaner energy source. I mean, we are already faced with an energy crisis. So that's question one. Question two comes from Fanny. It says, does the JET IP include financing for eco startups? That's question two. And then a question that I think Celine has already answered in some aspects, but I'd like you to speak about, because it says, are there some frameworks, guides, toolkits that facilitate the kind of scrutiny you advise, particularly for use by non-state actors as they participate in and inform decisions taken by state actors? And I know Fair Finance has a toolkit coming up, so I think it would be great for you to speak about that as well. So yeah, those three questions. Mishak, I see your hand, but I'll come back to you after Alia answers these.
Thanks, Yasira. I'll try and keep it short. And I think what I'm challenging myself to do as well is answer these questions from a human rights perspective as well, because I think that's the process that we're trying to adopt, particularly in a way that shifts the narrative, right, rather than financialized processes. So what is the alternative that we're offering, I think, as civil society, and an alternative to a financialized process? And so looking at the first question in terms of transitioning from the use of coal, we absolutely have an energy crisis. And I think the first thought that comes to mind is a video I was watching yesterday by the photographer Dalen Paul that reminded me about the costs of not transitioning. If we look at the way in which we do produce energy at the moment, Mpumalanga, one of our provinces, is one of the highest point sources of pollution in the country. And the costs of that type of energy production have not actually been taken into account when we look at energy provision. So really, really severe health impacts, damages to the environment that affect daily livelihoods of people as well. And so the position that I would take is, how do we actually look at the costs of the existing energy sources that we have, and whether or not that is a energy source that we are okay with continuing and perpetuating? Or can we actually look at energy sources that are cleaner and also more affordable at setting up in the future, in terms of solar energy, in particular, solar power in particular, but using these different energy sources as an opportunity to embed human rights and justice, where we look at diverse ownership options as well. Do we have local ownership models where communities can own their own power source and take decisions around their own energy provision as well? And what types of finance can support these models? And so when we look at the transition, I don't think we can afford to not. But I think the importance of focusing on how finance supports those who may stand to lose out on a transition, such as existing communities who have jobs in the sector, is of fundamental importance. And that's why, as the previous speakers have mentioned, using this as a blueprint that we scrutinize is critical. And then, as an example of that, we look at the amount of funding in the JETP and in the JETP IP for social protection, for worker compensation, for worker replacement. And then as civil society, how we actually advocate for more support for those just and social criteria and conditions as we move to a cleaner energy source in a way that addresses the energy crisis as well. In terms of funding for eco-businesses, from what I've seen in our, and maybe I can actually share, maybe, Yasira, I think I might just share some of our letters and comments as the Fair Finance Coalition with you afterwards. I can't find it quickly now. But in terms of eco-businesses being supported, what I know the coalition has called for is absolute support for social protection measures, but greater attention being paid to small scale investments in local areas. What are smaller businesses that can be supported? And what I'm seeing from Malaysia as well, I believe one of the speakers is also from Malaysia, is looking at how small businesses can also adopt sustainable social and environmental standards in their own ways of practicing. And so I don't actually know, I think that was part of the difficulty with the JETP IP. We don't actually know the projects that would be supported buy this funding. We don't know how it's going to be accessible, and we don't actually know the institutions that the financing will be implemented through. I think we're still also asking for detail around the monitoring and evaluation of this finance, which is where we argue that civil society and community-based organizations can play a very strong role. But how different businesses can access this, that's one of the questions. Does the JP for Eco Startups? Yasira, I forgot the third question, I'm sorry.
No, that was just on is there toolkits that guide this process?
Yes, so we are developing the toolkit at the moment, but in terms of how it is arranged, we're actually calling it more of an activist guide. And so that will be available soon, I hope. I think maybe, definitely by July. It's actually come back from layout and design today. But just as an idea of what it entails is looking at the existing development aid sector as well as the architecture through which this financing is coming out, but looking at different ways of engaging with financial institutions. So do grievance mechanisms work? We have plenty of examples of projects financed through development finance institutions where human rights abuses have taken place. So what are the instruments that we have at our that we technically have access to lodge grievances, and do they work and do they not? And in sites for engagement, do we have civil society forums as tools to engage with financial institutions? But I can share some more about that toolkit, I think, once it is developed. But looking at very basic definitions of what is climate finance, how can I use climate finance, how can I engage in the topic of climate finance? And when I say what we are doing to make it accessible, you know, we even trying to define what is debt, what is capital, what does it mean that there's going to be more debt as a country, and how that then affects the social spend in a country. So really trying to break it down at that level, and using case studies again as that approach of and more of a narrative approach of how we engage in this topic. But I know there are plans as well to have an online curriculum for this this topic on our website, the Fair Finance Coalition website, after this event of the Fair Finance School, but that's still in development. So we'll definitely be in conversation, I think, with a lot more of you guys, I think, Yasira, of how do we build up content and curriculum to actually mobilize and support people as they take up this task in their own sectors and communities and areas. When climate finance is being proposed and consultations are being proposed and arranged. I hope that answers the questions.
Thanks so much. Thanks so much. So I know we have a bit of a hard stop at 11:30. I don't see, oh, I see one more question in the chat. That maybe, I think it's maybe Anil could answer this one. Can you comment on Jet IP and the implementation of FCTFA's investment protocol? So Anil, if you could sum it up in like 2 minutes.
Yeah, I can quickly. There's obviously no reference to the investment protocol in Jet IP, but yeah, they will exist in parallel, and depending on it hasn't, as far as I know, it hasn't yet been adopted. So the investment protocol will apply to investments that are intra-Africa, you know, within the continent, moving investments. So I don't think necessarily the Africa will be central to the implementation of the Jet IP, because it kind of is aiming to bring investments from the global north, not within, you know, investments within Africa. But it is a standard setting instrument, the investment protocol, and it will have a significant influence, I think, on the evolution of investment protections within the continent. And I don't know what South Africa will do in terms of following those standards, but it is something to watch out for, I think.
Perfect. Thank you so much. So thanks everybody for coming through. I think it was a really fruitful discussion. Thank you to our speakers for everything that you guys have contributed. So yeah, like we mentioned, there's some upcoming things that the IHA has, which is Celine mentioned that in her answer to the one question, the toolkit that the IHA itself is developing on a human rights-based approach to climate financing and dissecting these topics and looking at the hidden institutional powers and power dynamics that exist and what this means. So it targeted specifically at civil society organizations and obviously in collaboration with the Fair Finance as well. So that's something to look out for. And yeah, thanks so much. Thanks so much, everybody. It was really great.